Hello, I'm Jonathan Rubens, Editor-in-Chief of Business Law Today. Welcome to our ongoing series of program spotlight interviews and author spotlight interviews. With me today, I'm pleased to have Keith Miller. Keith is with the Drake University School of Law in Des Moines, Iowa, and Keith is also the Vice Chair of the Gaming Law Committee here at the Business Law section. Keith is the author of a recent article that appeared on the businesslawtoday.org website, What's Next for Sports Betting in the United States? And this article comes from the fact that there was a very significant Supreme Court decision of earlier this year that involved essentially the invalidation of the longstanding law that governs sports betting in the U.S. So Keith, welcome to
Thank you.
The interview, and I'm excited to have you here to tell us about sports betting. So tell us about the recent Supreme Court case, the Murphy case, and what it means and what it did and why it's significant.
Well, it all goes back to this 1992 federal law, the Professional and Amateur Sports Protection Act, known as PASPA, which effectively limited sports betting to the state of Nevada.
Right.
But the important thing about it is it didn't accomplish that by passing a law which said sports betting is prohibited except in Nevada. What it did was say to states, you cannot pass a law that authorizes or licenses sports betting. And that difference between a direct prohibition of sports betting, where we have a federal law that outlaws it with an exception for Nevada, and what PASPA did, which was to tell the states you cannot pass a law that authorizes sports betting, that was really the key distinction which led to the constitutional challenge.
So as I recall, this law dates way back. I mean, this has been around, is it since the early 70s?
1992 was when it was passed, and it's also sometimes known as the Bradley Law. Senator Bill Bradley was a big proponent of it.
So why now? Why did the challenge finally happen now, and what gave way now? What was the factor that made the court take this up, and what was the court's rationale for finally ruling on this and challenging it?
It was a bruising process. New Jersey, that had challenged the law, they really took their lumps in the federal courts for a number of years until the case got to the Supreme Court.
And of course, New Jersey probably always had an interest, with the rise of gambling in Atlantic City and places like that. The sort of, lack of parity between places like New Jersey and what happened in the state of Nevada, I'm sure was the, part of what was involved with the longstanding interest in challenging the law.
Yeah, New Jersey chafed at the limitation of not being able to offer sports betting when their gambling competitor Nevada could. But when the law the case got to the Supreme Court, it was really an emphatic takedown of the law. 7 justices ruled in favor of the core ruling that the law was unconstitutional. And what the Supreme Court said to Congress was, if you want to regulate sports betting, you can. You have the constitutional authority to do that. But what you don't have the constitutional authority to do is to tell states, to dictate to state legislatures how they can and cannot legislate. And that's exactly what this federal law did. And the court said this is a case of commandeering. You are taking over a state legislature, and that is, according to the court, a direct affront to state sovereignty. So the decision's somewhat complex, but I think it can be summed up very succinctly, and that is, the Supreme Court said to Congress, if you want to regulate sports betting, you can. But if you don't, you can't prohibit the states from regulating it.
So something like 26 years later, this longstanding rule that basically limited sports betting to the casinos in Nevada is now gone. So is New Jersey instantly, creating a sports betting regime in the state? And are we going to see that in other places as well, the riverboats in the South?
Well, New Jersey didn't lose any time parlaying its victory into having sports books. Right now we have 5 states operating sports books. Nevada, of course, New Jersey, which has gotten off the ground very successfully, Delaware, Mississippi, and West Virginia. 2 other states, Pennsylvania and Rhode Island, will probably be up and running by the end of the year, and then there will be other states who will be considering it.
Right. Am I likely to see any sports betting places anytime soon in California?
California is really tricky because of constitutional amendments in the state. There are no commercial casinos that operate there. All the casinos that operate are operated by Indian tribes through compacts with the state. So the state would not be allowed to license sports betting at other sites around the state or at the horse tracks. They will have to work through the Indian tribes, and those negotiations between state and Indian tribes sometimes can be a little fractious.
And I gather there's probably similar regimes in other places as well that have Native American casinos operating now.
Yeah, Florida is another example of that. Connecticut with two very, very large tribal properties there. These will be things that will take a while to develop.
Right. Wow, so pretty significant. The case came down in May of this year, isn't that right? And you go over this in the article that's on the website. And I understand the gaming committee is also going to address this in a program at this fall meeting here in Austin. Tell us about the program.
We have a program on Friday afternoon where we're talking about some of the implications of the case, what we think is going to happen, what states are going to do, how state legislators need to enter into this carefully, and to just consider a number of the questions that are going to be coming up.
And can you tell us who will be speaking on the panel?
I'm not sure. We had someone who had to leave at the last minute, but I believe our chair, Carl Rutledge, is going to be there, and Glenn Light are two of the people I know are going to speak.
Terrific. And tell us more about the Gaming Law Committee here in the section, and what it's been doing and what it's up to and what it might be doing in the meetings to come.
Gaming Law Committee has, in the past few years, we have been resurgent, we think. We've been reaching out to a lot of people who had been members but had been somewhat inactive and trying to get some activities going. We're working very hard to establish connections with other committees, and one of the things that we're doing is trying to show the relevance of gaming law to other areas of business practice. And along those lines, we proposed a book. The book proposal has been accepted.
Oh, great.
That we've started to work on. That the working title is What Every Business Lawyer Needs to Know About Gaming.
Okay.
And we think it'll be a really valuable contribution to the practice.
And what kind of book will that be? Will that be a survey of gaming around the U.S. and the various regimes in the states and things like the recent Supreme Court case? And
we're going to look at several particular issues. We're going to describe the basic regulatory structure of gaming and then take particular issues and show how in the gaming area a business lawyer might have to deal with special considerations. For example, in dealing with Indian tribes, you have issues of sovereign immunity. With reorganizations and bankruptcies, there are different considerations that can come up with casinos, money laundering, debt collection, a number of issues that we're going to look at, and we're going to be very careful to try to direct it at someone who is not specializing in a gaming practice, but who may not even be aware that they have these issues in their practice, and just try to be a service to them.
Terrific. Well, great. Well, sounds great. And all of you, thanks for listening. Look for this forthcoming book from the Gaming Law Committee.
That's right.
At the end of this year or early next year, perhaps?
I would say the middle of 2019.
Okay, middle of next year. Look for this book from the Gaming Law Committee, and look for these programs that are taking place here at Austin that Keith just mentioned. And thanks for joining us for this further edition of Author Spotlight here in Business Law Today.